May it please the court, Doug Norman for the state. With the court's permission, I will be splitting my time with Mr. Ainsworth. I would like to address the issues concerning the scope of review and amendment of this application, as well as the Brady claims. Mr. Ainsworth will take the ineffective assistance of counsel claims. There will be some overlap, understandably. May it please the court. In our response, the state's brief, one of the things we have argued in this case is that we were basically given one application at the time it was filed, and the theory was radically changed by the time we went to a hearing, after this court had designated the issues. In particular, the initial application claimed that there was a low 48 indication on the readings of the stomach content that was not disclosed to them. It later became apparent in our research that we had disclosed that to them. On the eve of the hearing that this court had ordered, the theory changed to a 250 reading and an experiment that we had basically no notice of. It raises the question, to what extent can a habeas applicant change their theory after the application has been filed, after this court has designated issues and sent it back for a hearing? On the eve of that hearing, the state basically had no notice of it, and we did preserve all along our objection to the fact they had changed their theory. Now, in my brief, I have underlined those portions of their claims that have changed. They changed a number of claims. The lower 48 to the 250 was the main claim that they changed. They changed a number of them there. We make the arguments in our brief that I will stand on, that an application for habeas corpus in the 1107 statute is mentioned as an application. It shouldn't be multiple applications. We urge this court to read it as a single application.
Mr. Norman, we normally allow all kinds of amendments and supplementation and so forth, so long as those amendments and supplements go through the trial court and it's made before we've come to some decision. Are you saying that we've been wrong in doing that?
I would certainly like for you to find that, Your Honor, because it's unfair to the state, I would argue, to allow the defense to lay behind the law and change their theory on us.
But if we get only one, and as I recall the statute back in 1995 when it was enacted, it was said that it was to be one full opportunity, and that the defense, and it was Senator Pete Gallego who said, bring the kitchen sink and put it in. Put in everything that claims that you learn about, because you only get one opportunity, and so you want to make sure that every possible issue has been addressed. And so we sort of use that as, a rationale for, yes, we'll allow free supplementation and amendment. Are you saying that we should not be doing that?
I'm urging the court not to. I think it's certainly bring everything, including the kitchen sink, but bring it when you file the application. Don't throw the kitchen sink at the state at the last minute, which is what happened in this case. There is clear testimony as well in the writ hearing that the attorneys examined our files, and we gave them free access to our files in 2010. They had all the information that they would need to have made the claims they did, the additional claims, way before they filed their application in 2011. And we would certainly urge this court to look carefully at that. I understand that common practice has evolved into amending these things continually. There's no provision, specific provision in the 1107 for amendment, but it seems that more and more habeas applicants, especially those represented by counsel, are amending their claims after the issues have been designated, after this court has sent the case back for its own designation of issues. It happens at the last minute. The state gets no notice of it. I would urge you either to read the statute conservatively, not to allow such amendment, at least not without some sort of leave of court to amend it at that late date, or to find, based on this court's general application of laches, it's simply unfair to the state to allow amendment at that late date. And there is prejudice to the state, because once they've made their initial claim, and we've expended numerous man-hours responding to the claims that they've made in that, to allow them then to amend it and add or change their theories, in fact, it wastes the state's time on having responded and thoroughly looked at the claims before made.
Should that be a very hard and fast rule?
Well, Your Honor, I think there is plenty of room for subsequently discovered things if in the courts, as I said, I think the court could allow amendment, on a case-by-case basis when it's asked for and when leave of court is granted. Understand, in this case, the court had already designated the issues, and it was later amended. This court, Your Honor. Procedural history was the trial court initially simply signed an order saying he didn't find that there were issues in the case and sent it out. This court found there were issues and sent it back with specific instructions to have a hearing on designated issues. And it was after that the claims were changed. We would urge the court to limit this. If, on the other hand, there are claims that legitimately could not have been discovered at the time that the initial application was filed, then they have the subsequent application process that they can file. They can claim we were not able to, actually unable to raise these claims before, and that would excuse failing to raise them in the initial writ.
On a practical basis, I understand that you feel that you're being sandbagged there, but which would you prefer bottom line? Litigate it once, litigate it twice?
I'd like a fair opportunity to litigate it twice as opposed to being sandbagged once. And please understand me, Your Honor, I'm not claiming the counsel did anything unethical. I think they were doing what they felt was in the best interest of their client. I assume they didn't realize, they hadn't looked at the things carefully enough to realize their, the claims they eventually made. So I'm not accusing them of doing anything wrong. I'm saying allowing this sort of thing in general sets a very bad precedent for the state, and it allows us to be sandbagged in case after case in these 1107 proceedings.
Mr. Norman, honestly, when I read your brief, I read it exactly the way you're arguing it right now, which is that you're arguing this procedural default argument. The problem is, when I read your brief, I then also thought he must lose on the merits. So I wonder if you could address the merits.
Yeah, and I mean, I don't think we lose on the merits.
Well, that's what I'd be interested in.
And on the merits, I'm going to cover, if I may, I think the most important thing here, the one thing that's been argued is the smoking gun of the 48 or 250, whichever you want to look at it as. And, initially I'd just like to mention there was a claim here that there was a misrepresentation that this was a lodge. In fact, there's no credible evidence that there was such a misrepresentation. The testimony that's pointed to is a testimony of one of the trial lawyers, Mr. David Jones. He testified that he was starting to testify that one of the other defense lawyers of the defense team had learned that it was lavage, supposedly from the prosecution. And we said hearsay, and the trial court agreed with us. He didn't hear it himself. This was something he supposedly heard from the defense team.
What did the bag say?
The bag said Bemis, gastric content, I believe, and it was labeled with a home address, but everything was. The standard police procedure was to list the name of the defendant and the home address. If they looked at it carefully, they'd see that everything was listed with that home
Even the
address.
stuff that was taken to the hospital?
Yes, Your Honor, yes. I believe so.
Perhaps you should speak to the police department about that.
Well, yes, Your Honor, but I mean, it's clear under their procedure.
However, it wasn't known. Do you agree with the defense that this was really important evidence? It's sort of, the smoking gun type evidence that supports their defense.
No, I really don't, Your
Okay,
Honor.
why doesn't it? Why isn't it important?
If I may construct what I think their defense is, I think their defense is that with this 250 level in the stomach, that somehow proved that the decedent, Andrew, was salt poisoned long before we supposedly claimed he was. That he somehow got into the stuff himself rather than being force-fed. That would assume that our theory was that Hannah Overton force-fed the child this stuff right before she took him to the hospital. And that was never our theory. Our theory was that he was force-fed several hours before. We don't know exactly when. Our main theory was that she did nothing. She stood there and watched him deteriorate for a significant enough period of time that he wouldn't survive and that anyone should have known that he was dying. This is actually consistent with our theory. If we can show that some 2 or 3 hours beforehand was the time that he actually ingested sodium, that really dovetails with the state's theory and not the defense's. That shows the theory we primarily argued at trial, which was one of omission. She sat there, she watched her child die from sodium poisoning.
Are you saying that she didn't feed him the salt?
Well, no, I'm saying, the gastric contents don't tell you who fed him the salt.
Right, but are you saying, it's got to be either she fed him the salt, for the second theory, she fed him the salt, and so she's doubly too dreadful. She not only tries to kill him, but she sits there for another 2 hours and watches him die. Or Are you saying that she watched him eat the salt himself and did nothing, or?
I'm saying, under the second theory, Your Honor, that she, however he ingested the sodium, whether she gave it to him or whether she didn't see him take
But
it.
I mean, I think her position was she was taking a nap, and he was out, he was supposed to be in his room, but he wasn't. So are you saying that it doesn't matter if he ate the salt all by himself with nobody watching, that any reasonable person would have picked up on this?
According to her admissions, there was a significant period of time, approximately 2 hours, when she was aware that he was sick, and before she took him into the hospital, 1.5 to 2 hours. That's the critical portion.
The question was, are you saying that it doesn't matter? And you charged him with two theories, right?
Yes, Your Honor, omission
One was
and
eating
commission.
the salt, and the other one was not taking to the hospital, right?
Yes, Your Honor.
Essentially.
And, I mean, in a nutshell, yes, I don't think it matters. And the theory that the jury bought, because we know from the polling, was omission. That was what they all agreed. They convicted her on omission rather than commission.
I'm sorry.
Was there any testimony about the symptoms of, what do you call it?
Hypernatremia.
Hypernatremia. And we did a case a few months ago where a child died and someone got charged with, he could not take him to the hospital, and yet there was testimony that they were symptoms that an untrained, unmedically trained person would not recognize as being critical. So was there any testimony about whether a parent with no medical training would even know that there was such a thing and know what the symptoms were and therefore react?
Well, a couple things, Your Honor. One, she was a trained EMT. She had been trained in shock and had at least some knowledge of sodium levels in the body. But the
Was she an
second,
LVN?
beg your pardon, Your Honor?
Was she an LVN as well?
I believe she was, yes, as well. The second, and what I find the most critical portion in examining that, is her initial admissions to the personnel at the urgent care center. That at some point, which I think we can, from other testimony, we can narrow down to the point when she first noticed Andrew was in trouble. She first noticed something was wrong with him, which would be 1.5 to 2 hours before. She admitted to the personnel that she noticed he was not breathing. Throw out all the medical training, throw out everything else. If a parent notices their child is not breathing, they get him to the hospital.
The child was not dead on arrival.
Well, no, and
When you stop breathing, you got 3 to 5 minutes. I remember.
exactly. I understand that, but I mean, we're talking about her knowledge and what she thought at the time. The time she noticed he was in trouble, she thought he wasn't breathing. Obviously, he was still breathing, perhaps, we don't know, perhaps, slowly, perhaps imperceptibly. But the key question there is her knowledge that something was wrong and her getting him to the hospital. And I would assert that when a parent thinks, correctly or incorrectly, that their child is not breathing, they get them to the hospital.
Was there testimony?
One quick question, just to clarify. So you're saying the child was not breathing, and then she delayed 1.5 hours before she took the child to the hospital. Is that what you're saying?
If you take her admissions to the urgent care center personnel, and if you take the rest of the testimony, yes, I think that's a consistent, that's consistent
So the
inference.
been breathing for 1.5 hours and then he's still alive.
So she believed, Your Honor, at one point that he was not breathing and did nothing. And as I say, he must have been shallowly breathing, but
The question I was going to ask, wasn't there testimony, I can't remember who from, that to all intents and purposes he was dead when he was kept alive for a day or two, and he was dead when he got to the urgent care center, his pupils were blown, he was blue, cold, and had no pulse and was not breathing?
yes, he went into cardiac arrest before he came to the center while he was being transported. He was resuscitated. He lived for, I don't know, I don't want to represent the court how long, a few hours, maybe a day, I'm not sure, but a short period of time. Unconscious, yes.
That's, to follow up on that, that's what I found so bizarre, among other things, but that there's evidence that she was doing CPR while they were at a clinic or hospital, and I thought, well, what parent does CPR when there's doctors and nurses around in the hospital? So I wonder if you could clarify.
Well, it was an urgent care center, which is attached to Driscoll Hospital.
But wouldn't the child immediately be taken at that point? I mean, parents don't do CPR in a hospital or an urgent care. That's what the nurses and the doctors do.
Yeah, I think the testimony was there wasn't a crash kit there, and this was apparently, for whatever reason, they were not set up to do CPR. Your Honor, if I may, I would like for my co-counsel to get an opportunity to argue. May I turn it over to him at this point, Your
Thank
Honor?
you.
Did you say they weren't trained to do CPR?
It's my understanding that that was not a common practice at the urgent care center. I don't know if they had, somebody there may have had basic training, but she was on the spot, and Ms. Overton apparently did.
This was in Driscoll, which is a small town, isn't it, outside of course?
Oh, no, I'm sorry, Your Honor. Driscoll Children's Hospital
Oh.
is a major children's hospital. The urgent care center is a sort of an adjunct of Driscoll
I see.
Children's Care. It's where
Sure, okay.
you take your child if you don't want to get stuck in the emergency room all day. Supposedly, it streamlines the process.
So urgent care doesn't really mean urgent care, it just means what? That doesn't even make sense to me.
It's somewhere between, a regular clinic and an emergency room, Your Honor, as best I can tell.
You don't go to an urgent care facility to get urgent care.
Your guess is as good as mine, Your Honor.
I think the defense made that point.